All right. Good luck, guys. I'll be watching.
Thanks, Drew, for everything.
All right.
Meg Garvin, are you with us?
I am. I'm excited to be here. Yes.
Great. Meg, I want to welcome you to our first in an interview series created by Marsy's Law. First, I want to welcome everybody that tuned in and tell you first a little bit about Marsy's Law to the people in the victims' rights movement who are tuning in. Marsy's Law is named after Marsy Nicholas of California. Marsy was stalked and killed by her ex-boyfriend in 1983. Only 1 week after she died, Marsy's mother and her brother, Dr. Henry T. Nicholas, walked into a grocery store where they were confronted by the accused murderer. Their family, who had just come from a visit to Marsy's grave, was totally unaware that the accused murderer had actually been released on bail. In an effort to honor his sister, Dr. Nicholas has made it his life mission to give victims and their families constitutional protections and enforceable rights in state constitutions throughout the country. He formed Marsy's Law for All in 2009, and he's been providing expertise and resources to victims' rights organizations nationwide ever since. And I want to welcome everyone to our first interview in a series called Why We Do What We Do, where we're going to be introducing viewers to the ongoing efforts of Marsy's Law and the victims' rights movement in general through the people who work so hard on behalf of crime victims every day. And one thing that we know and that I've realized is that all of us in the movement have a unique passion and sometimes a personal story that has brought us to the crime victims movement and to this work that motivates us. And sometimes it's pointed us to this work in the first place. And it's what I like to call why we do what we do, and that's the name for this series. And our first guest I'm really honored to host is no exception, and that's Meg Garvin from NCVLI, National Crime Victim Law Institute. And Meg, I'm just going to introduce you very quickly by way of Meg's bio. Meg is the executive director of the National Crime Victim Law Institute. She's a tireless advocate for crime victims, a leading lawyer and an expert on victims' rights. She's testified before Congress, state legislatures, and the Judicial Proceedings Panel on Sexual Assault in the Military. She serves on the Defense Advisory Committee on Investigation, Prosecution, and Defense of Sexual Assault in the Armed Forces, and on the Victims Advisory Group of the United States Sentencing Commission. Meg is also a clinical professor of law at the Lewis and Clark Institute, and we are proud to count Meg as an ally in our cause and an advisor for Marsy's Law, where she conducts trainings, she advises on language, she testifies before state legislatures on behalf of Marsy's Law, why constitutional rights and enforceable constitutional rights for victims are so important as it compares to statutory rights. And we're going to get into that as well with Meg. And Meg's history with Marsy's Law goes back to the very beginning, where she actually advised on the very first Marsy's Law language in California back in 2009. So Meg, I want to thank you so much for joining us. And your experience with victims' rights, like I talked about, personal stories that may have led us subconsciously or otherwise to the victims' rights world. Your experience with victims' rights actually begins while you're in law school, but not necessarily studying it. Could you tell us a little bit about that?
Yeah, I'm happy to. And I'm really happy to be here and honored to be here. It's exciting to think about talking with folks about why we do what we do. Because as you noted, Peter, sometimes it's very conscious. Like we go into something with a ton of intention. Other times we all take circuitous routes to get there. Mine coming to the victims rights movement in particular is a little circuitous. I had done some volunteer work throughout my various schoolings, including with some survivor groups. But when I was in law school, I went to law school as kind of a second career in many ways. I'd already been doing other things. When I went to law school, my intention was to be a public defender. And so I went to school with that intention, and I was really fortunate to be working in an excellent public defense office in Minneapolis during law school as an intern, right? But kind of learning things. And one night while I was in law school, my second year, I and two of my friends were out and we were leaving a bar and walking down a pretty busy road. And as we turned off that road, we were approached by two people. One was across the street kind of hanging out, and the other one approached us. And I actually ended up being a victim of crime that night. I was held up at gunpoint, as were my two friends. And it's really interesting because even today, I'm struggling to tell the story, not because I'm being triggered by it, but because I'm trying not to do what I often do as a survivor, which is minimize it and also try to say, I did everything right. I used to tell the story of saying, I did everything right. I had mace in my pocket. I was walking with two men who were both 6 feet tall, and I still got held up at gunpoint. Well, you know, me telling the story that way for a decade was problematic because it was blaming myself and pretending that some victim could actually not be held up at gunpoint. But I was held up at gunpoint, and fortunately, I won't go into the details of what happened, but fortunately, there were a lot of things that went well for us that night that went poorly for the offenders that night. But then they did find one of the offenders that same night. They did a show up lineup where they, not even a lineup, just a show up identification. We were able to identify one of the two gentlemen. And then from there, basically what happened is I was a victim, and it was very clear I was a victim. But now with the knowledge I have, what also is clear is that I was not afforded any rights. And I didn't know it. Even being a law student, being a well-educated person, having tons of resources in my life, did not understand why the system was ignoring me, but essentially the system ignored me. And I only heard about the case kind of through phone calls periodically and asked to submit a victim impact statement. Never any indication of when sentencing was, just submit this darn thing. So I did, and then I found out later that I'm not even sure the judge read it. So so I came to victims' rights by being a victim and never even knowing I had rights, even though Minnesota had rights on the books at the time. And in retrospect, I think to myself, how on earth was I okay with the crumbs that I was given by criminal justice? Like, it happened to me, it changed my career trajectory. I didn't stay in public defense. It really actually changed the way I walk down streets. It changed pretty much everything for me. But at the time, criminal justice just kind of treated me like it does many victims, which is as a piece of evidence.
So not only were you unaware of whether or not your victim impact statement had any impact because you weren't even aware of whether or not the judge read it, you were not even notified of the sentencing hearing or the disposition of the case at the time.
Yeah, well, here's the interesting thing, Peter. To the best of my recollection, I wasn't. And so as I've tried to navigate all of this myself, like, I have no knowledge of when the sentencing happened, which means however someone tried, even if they tried to communicate it to me, it didn't work, which means that my right to be notified of sentencing was not meaningful, right? And so that's one of the really interesting things about victims' rights is even, and maybe there's some document somewhere in the file that says someone called me, someone left me a message. I have no idea, because at the time and continuing to this day, 20-ish years later, I have no recollection of ever having been told when sentencing was, or understanding what I believe now was a plea agreement, what the plea was, which means my rights were not meaningfully afforded to me. And that's a really important part of rights enforcement, is they have to be meaningful. Checking a box is not meaningful rights. And that's what's so exciting about Marsy's law, is like, it's this move to make rights meaningful, and to not just have it be kind of a rote thing or a check the box thing. I mean, I can only wish that we had Marsy's law when I was a victim then, and I've had other experiences since.
Right, and that has been the goal since the beginning for Dr. Nicholas, and the purpose is to have both meaningful and enforceable constitutional rights for victims. Like you said, rights for victims can be on the books. They can be on the books by statute or otherwise. But if they're not meaningful rights and they're not enforceable rights, like you said, they may well as not even exist. And so then you joined a law firm in Minnesota, and you said, like you said, you did some work as a public defender, obviously understanding the need and the importance of civil rights and constitutional rights in the criminal justice system. And then in 2002, I think it was, you saw a job posting for National Crime Victims Law Institute, and you answered that call. Can you tell us about that?
I did, yeah. So even though I was at a law firm, and so my pro bono service was, some of my pro bono service was appellate public defense. Because even, my core values, they stayed intact. My victimization did not touch my core values. My core values are that the individual human beings in our justice system need a voice. And so I stayed committed to public defense. I just couldn't do it at the trial level. But as I was at the law firm, which I loved, it was a great law firm. And I'm actually going to call them out. Naslin, Edelman, Borman, and Brand in Minneapolis is a phenomenal law firm. I was privileged to work there. But when I was there, I was also finding that while I was learning a lot and I was surrounded by great ethical lawyers, I wasn't being fed, like deeply fed by it. So I started looking around for jobs, and I also was looking on the West Coast to be closer to family who's down in California. Wasn't sure I wanted to be in California. And I applied to public defense jobs. I actually was offered some. And I should clarify, I was offered one, and I was applying for some teaching things. And then I saw this job posting for the National Crime Victim Law Institute. And truth be told, I read the job description and went, what on earth are they talking about? What is a victim's lawyer? And I had two thoughts. One, I didn't want to do protective order type work, and I didn't want to do family violence type work, which is one way of serving survivors. Because I knew I didn't have the temperament for that kind of work, and my passion was criminal justice. And then my second thought was, is this a law and order movement? Is this a truth in sentencing? Is that what they're trying to do? And I called Doug Bloof, who's the founder of NCVLI and who was starting up NCVLI at the time. And I called him. I didn't submit my resume. I just called him and I said, I'd like to have some of your time, Professor Bloof. And he said, well, if you're interested, submit your resume. And I said, well, I'd first like to ask you some questions. Anyhow, I talked to Doug for 2 hours on the phone, asking him tons of questions about the values underpinning NCVLI and their vision. And when I came out the other end of that call, what I knew was it was a civil rights movement that was committed to survivors' individual voice, that it was about making sure that no one stole that voice, not the prosecution, not the court, not the defense, that the survivor got to be present with their own voice, say what they needed, and that was how we were going to kind of adjust the criminal justice system. And once I knew that, I submitted my application, I pestered, I got the job, I picked up and moved cross country just a couple of months later and got here. I actually left Minnesota on Valentine's Day of 2003, which was a Saturday, I think, and I started work on Monday, the following Monday. So just a couple of days later, because I was so excited to start.
Yeah, and it's been quite a journey for you, and it's also been quite a journey for the victims' rights movement that you've probably been able to see unfold in real time. And one of the things that you do on behalf of Marsy's Law is conduct trainings, and you've talked to us a lot in different forums about the evolution of the role of the victim and the place of the victim and the survivor in the criminal justice system. Can you tell us a little bit about that?
Yeah, anyone who has seen me train knows I kind of geek out on the history of all of this. And so I won't go down the whole history path, but I think, there's a visual that I often have us think about, and it's the actual courtroom, right? And we design everything in our lives with some level of intention, and architecture is designed with a lot of intention. And so the visual I often use is like for everyone to like picture a criminal courtroom, right? And it's a really useful exercise, whether you close your eyes, whether you don't, but really actually in your mind's eye, see what you see as a criminal courtroom. And when you do that, to a T in this country, right, in the United States, when we have a common law history of how we've evolved the criminal justice system, as opposed to a civil law, what most people will see if they have any familiarity, whether it's from TV or personal experience, is you see a judge sitting up front and you see in your mind's eye 2 tables, a little bar, and then a bunch of seats, and then there's a door. And what is interesting is to try to unpack that visual and wonder where on earth is the victim sitting? Because if you think about it, right, there's a designated seat for the prosecutor. There's a designated seat for the defense attorney and the defendant. There are rows for the audience, right? Like that there's some sort of play going on, right? The citizens can observe the play, but there is no designated seat for the survivor. And in fact, historically, there was this moment in our evolution of criminal justice when we first started, victims were up there, they had a seat, they were in front of the bar. And then as history progressed from our colonization until the mid 1900s, the victim kept being moved back. First they had a seat, then they were behind the bar. And then in the 1970s, we passed some rules of procedure that basically said victims could be excluded completely from the courtroom. So if you go back to the vision in your mind's eye, you have this reality of whether it's a sexual assault, domestic violence, being held up at gunpoint, murder, right? It doesn't matter. It was about me. The crime's about me. And yet the system has said, oh, you don't have a seat up front where all the action happens. Oh, and you know what? Sometimes you might have a seat in the audience, but really sometimes you're outside. And so then if you think about that from a human perspective, it means it was me, it was my body. It was my life that was hurt. And now I'm peeking through a darn crack in the door to figure out what the heck is happening. Victims' rights said, that's ridiculous. It is absurd that that is how criminal justice is treating survivors because it's not going to help our communities. So open up the door, let them back in. And in fact, don't let them just have a seat in the back, but let them have a seat in the well of the court if they have a right at stake. And yeah, so that visual to me is just everything. If we can just pay attention to the architecture of our courtrooms and say, where should a survivor be? Where should we honor that it was them that was hurt? We'll start moving them forward again.
Yes, and you've done so much to try to gain a position of power and a seat of power for a victim. And there's nothing more powerful, as you and I have discussed, than constitutional rights. And you and I talked about a class of yours in law school that you took that was particularly impactful, where you learned all about leveraging the power of a state constitution. And at first that led you to your work as a public defender and realizing how powerful the constitutional rights afforded the accused are in the criminal justice system. And then you worked with victims and survivors and realized increasingly, as you were, and I have talked many times in the past, about the importance of constitutional rights for victims, which brings you and brought you to advising on the very first version of Marsy's law on the state, at the state level in California in 2009. Can you tell us a little bit about the parallels of the public defender work you did and the work on behalf of victims, particularly when it comes to how important constitutional rights are for victims?
Yeah, that class, as I reflect on my law school career, it was, again, I came to law school later in my life, and I was kind of taking classes to get to where I wanted to be, and that was doing civil rights work, possibly public defense work, which was my focus at the time. And there was this class that was offered, and it was about leveraging state constitutional rights. And most of law school, you're paying attention, as you know, right, to the federal constitution. And you even don't get a lot of practice with your state statutes because you're looking at broad propositions of law that govern everybody in the country. Well, this was a class about leveraging the Minnesota state constitution. And it was because Minnesota state constitution afforded defendants actually stronger rights than the US Constitution in certain areas. But it was mostly this class about, don't forget that there's a hierarchy of law, that as you move up the rungs of a ladder, right, the law becomes stronger. And so if you have rights at the highest rung of the ladder, the US Constitution, then in an argument, in a debate, you have a higher ground, you're likely going to win the argument. The next level down is state constitution, then statutes, and then rules. Generally, statutes and rules go in that order. And so this class was all about, yes, there's the US Constitution, but our state constitutions are the value statements of our state. So wherever we reside, your state values are embedded in your state constitution, and they have to have weight and meaning. And so I remember being fascinated by this because it opened my eyes to different ways to litigate. And so I was always citing the US Constitution and state constitutions. And I was so excited to move into hopefully being a defense attorney to protect that person's voice. And as my career moved and as I moved into NCVLI, you know, when I took the job at NCVLI, I did what many folks do. I tried to research, right? And so I was like, well, before I start, I need to know what the law is. And so I actually did a Westlaw search, which is, right, there's Westlaw and Lexis, which are two of the databases lawyers use a lot. And when I started in 2003, right before I started, I did a Westlaw and Lexis search for the state constitutional amendments that had been passed up until then to see what have courts said about these laws. And when I did that search, almost no cases came up anywhere in the country, which means that courts weren't speaking about the rights, which means no one was litigating the rights, which means the rights were not meaningful. Because rights only have meaning when they get litigated and we have a court saying yes or no, this is what it means. But when they lay there dormant, they don't have a lot of meaning. And this was this moment for me of why, if the laws exist, do we not have case law interpreting them? What is going wrong here? And part of it harkened back to, we don't have lawyers looking at state constitutions saying, oh my gosh, we need to do something with these. And when we finally did start doing it, when NCVLI started like putting lawyers in the field by partnering with folks, one of the things we found is, yeah, we could do a lot when the laws were strong. When there's clear enforceability in those state constitutions, we can ensure you can't ignore a survivor's voice. But when you only have statutes, right, too often those get ignored because the defense can cite, or this government can cite, a higher level law on the ladder. And so what we found was there were different strengths of laws for victims. If you had a strong constitution, and at the time, for instance, Arizona did, you were golden and we could do something for survivors. If you didn't, then the rights were just words on paper. And so it all went back to that law school class where I started to say, survivors need not just constitutional rights, but strong, enforceable constitutional rights. That's how we'll change the system. And so that's been the focus ever since. And so, and I don't know if that lawyer who taught that class, who was a public defender, would be excited or not, but his class stuck with me.
Well, thank God it did. And it points exactly to the reason and the purpose for Marsy's Law and the passage of Marsy's Law in our efforts in states across the nation. Like you said so well, what a state constitution says about a state, it's really a value statement about what the culture of that state is and what importance a state places on different values. And when it comes to constitutional rights for victims, like you said, they become meaningful and enforceable when they're in a state constitution with respect to the hierarchy of law, as opposed to just in statute. And one thing I wanted to shift to was with respect to the coronavirus. As we've seen, it's on everybody's mind, obviously, all across the world these days. And it's had repercussions everywhere and in every phase of everyone's life. And the criminal justice system is no exception. But you know, you and I have talked about this. While stores can close and even courtrooms can close, victims' rights can never be suspended. But courts have struggled over the last few weeks trying to administer justice in a way that we're actually having this interview remotely. And although they may not know it, they are suspending victims' rights at the same time. And you've had to get involved with respect to victims' rights, right to privacy and safety being infringed upon as a result of remote criminal justice. Can you tell us about that?
Yeah, you know, the rate at which we're having to make policy decisions in criminal justice right now due to COVID-19 and the coronavirus is resulting in kind of backseating or moving victims' rights back behind the bar again. And we need to be vigilant to make sure that they are front and center. So for instance, when courts are moving towards live streaming hearings, that's a problem because it might implicate a victim's right to safety, to be reasonable protection, and or to privacy, right? So right now, I intentionally didn't put up a background just to demonstrate this point. Let's say even you accommodated me, you notified me, court, and you are affording me my right to be present, but you say it's going to be by video. And you say, I need you to come on video, survivor, and testify or share something, right? So right now in my background, there's a whole lot of information about me, right? And if a court says we're going to live stream this and we're not going to edit any of it, that's a problem, right? That's a huge problem because it's not a courtroom with 20 people where it's a controlled setting. It is live streamed to the world. And this is what we're seeing. We're seeing courts use YouTube, use Zoom, use lots of things without factoring moments of protection. So we're having to really work with courts, both through litigation and policy letters saying, hit the pause button. We know we have to move justice forward. It's good, right? And you need to factor, do I have to not have this be a public hearing, right? Not have it be a public Zoom or a public YouTube? Is it not going to live stream? Is it going to instead be posted after we can redact? Are we going to allow alternative means of presence? All of these things. So we have worked in Washington, Texas, Michigan, Washington, DC, Oregon with the courts, either through litigation or policy letters on those issues, as well as notification of hearings. Boy, in the urge to release to save lives in our jails, which is a valid concern, we cannot sacrifice notifying victims that there might be a release hearing happening. It's really critical. And so we've also had to kind of raise the flag and say, whoa, you cannot just release people without factoring victims' rights.
Yeah, and like you were talking about, the public health versus public safety balance is really tricky these days. And there are a lot of states that are trying to release prisoners, and the statewide policies differ. One of the things that you've got involved in, all of the states that you've told me that you've gotten involved in, and you just told all of us, Washington State being one of them. And that just underscores the importance, as you were saying. Can you tell us how that underscores the importance of having victims' rights be enshrined in state constitutions as opposed to just statutes?
Yeah, it's an interesting situation up in Washington because Washington State does have constitutional rights for victims, but the clarity of notification rights is in statutes. And in an executive order, the governor, in response to COVID and in response to trying to ensure the health and safety of folks who are detained, suspended certain statutory rights, including notification of release, to expedite is my assumption, right? But the problem is that suspension of statutory rights wiped out notice to individual victims that certain things might happen. And, you know, I have no way of knowing exactly how it would have been handled if those rights were in Constitution, but I have a strong suspicion that it would have been harder for a governor, as well as drawn more attention if a governor had said, I'm suspending a constitutional right, right? We don't suspend constitutional rights without a lot of attention. There are cases from the Civil War until World War II, until the Vietnam War, talking about when can you suspend civil rights and when can't you? And it is a big moment to suspend a constitutional right. But these rights were in statute and they got suspended. And so we had to fight a little bit harder to try and make sure the victims' rights, which were in statute, but only in statute, got factored into decision-making. So it really is just another moment to say, stop putting the victims at a lower level. They are a part of this. They should be at a level that no one can ignore. They don't control it, but they have to be in the conversation. You don't develop policy without talking to victims.
Which once again validates and underscores the importance of the work of Marsy's Law so that we can enshrine meaningful and enforceable constitutional rights in states all across the country. And Meg, you know, you and I talked about the fact that, you know, this is poses additional challenges to domestic violence victims and child abuse victims. We have to wrap up now, but you know, it's clear that no matter what happens, victims' rights can never be suspended, and that there is no vaccination for violence. But we can give victims, while we can't give them necessarily a vaccine, we can give them a voice, no matter what the circumstances are. So Meg, I just want to thank you, because that's all you do every single day, is try to give victims a voice. And with your help, that's what we do at Marsy's Law, is try to give victims a voice by giving them meaningful and enforceable constitutional rights. So thank you, Meg, for all the work you do and continue to do. And I look forward to welcoming our next guest on why we do what we do on the interview series created by Marsy's Law. So thanks everybody for joining. And thank you so much, Meg, for taking so much time out of your day today.
Thanks, Peter, very much.